We'll move on now to Professor Mark Movsesian, who is Frederick A. Whitney Professor and co-director of the Center for Law and Religion at St. John's University.
Thanks, everybody. Can you hear me? Can people hear me? Yeah?
Yes.
Okay,
Thank you
great.
so much, Professor Movsesian. Great to see you.
Oh, thanks so much. Thank you for having me. I really appreciate the invitation. I ask if you can hear because that's always the question that one has to ask at these things. Well, my contribution, which is called RFRA and the New Thoreaus, explores how the large increase in the number of the religiously unaffiliated in the US, this is the so-called rise of the nuns, may complicate the application of RFRA, and why religion, for RFRA purposes and other legal purposes, should presumptively mean a collective rather than a purely personal phenomenon. So, as everyone knows, RFRA, and as well as its state law analogs, the so-called little RFRAs or state RFRAs, requires the government to provide religious exemptions from civil law in certain circumstances. And Kenneth Townsend just said, RFRA provides that a law cannot substantially burden a person's exercise of religion without a showing that the state has a compelling interest and that the state has chosen the least restrictive means of advancing that interest. So the very first element in a RFRA claim is that the claimant is exercising a religion. Everything turns on that. If the claimant isn't exercising a religion, then RFRA doesn't apply. Now, when Congress passed RFRA 30 years ago, there wasn't too much question, practically speaking, about what it meant to exercise a religion. True, the US has always been a religiously diverse place, and a handful of cases from the Supreme Court that try to define religion point in different directions. But as a social and cultural matter, religion in the US meant conventional organized religion. In 1993, when RFRA was enacted, more than 90% of Americans told the General Social Survey that they had a formal religious affiliation, Catholic, Protestant, Jewish, etc. Now, that doesn't mean that everyone in these categories believed the same things or behaved in the same ways, obviously not. And we've always had idiosyncratic believers in America, going all the way back to the transcendentalists like Thoreau, and even before that. But the fact that more than 90% of Americans identified with conventional religion suggests that, practically speaking, the overwhelming majority of people understood religion in traditional terms. That is, as a community of believers that exists across time with a common set of beliefs and practices that in one sense or another bound the community together. In the last 30 years, that situation has changed dramatically. The number of religiously unaffiliated Americans has exploded. Today, 29% of Americans say that they don't have a religious affiliation. When they are asked their religious affiliation on surveys, they respond, none. And that amounts to something like 95 million people in America today. Now, many factors explain the rise of the nuns, including changes in family structure and generational replacement and the sexual revolution. For my purposes, though, the crucial observation is this. The large majority of nuns are neither atheists nor agnostics. Rather, they're unaffiliated believers who fashion their own DIY religions, often combining elements of different and indeed opposed faith traditions. Nuns reject exclusive institutional religion, not spiritual commitments as such. In fact, it's good to think of them as spiritual independents. To use a phrase that was popular a decade or so ago, they are the spiritual but not religious. As a result, today's nuns are the spiritual descendants of the 19th century transcendentalists. They are the new Thoreaus. Unlike the transcendentalists, though, the new Thoreaus are a mass phenomenon. And slowly but surely, they have begun to appear in the courts, mostly outside the RFRA context for now, but I think that may well change. They've begun to appear in the courts claiming exemptions from legal requirements based on their religious beliefs, including a number of challenges to COVID-19 mask and vaccination requirements. I argue in my essay that the rise of the nuns will put increasing pressure on that very first element of a RFRA claim. Do entirely personal, idiosyncratic spiritual commitments qualify as a religion? Another way to say it is, can spiritual independence receive religious exemptions? Now, as a matter of statutory interpretation, the answer isn't clear. RFRA suggests that its definition of religion should be tied to the First Amendment. And it also, at present, it defines religion as, quote, any exercise of religion, whether or not compelled by or central to a system of religious belief. Now, that suggests that idiosyncratic commitments can qualify for protection under religion, as long as those commitments are religious in character. And that's the question we're asking. Do personal spiritual commitments that aren't tied to a system of belief, to a traditional religious community, do they qualify as religious? Or, since we're academics who are free to ask normative questions rather than lawyers who are simply seeking to interpret a statutory text, we can ask it this way. Should such commitments qualify for protection under RFRA and other legal texts? In my contribution, I argue for a flexible approach. Presumptively, religion should mean a collective phenomenon rather than a solitary spiritual quest. Such a presumption fits with common understandings of what religion means and promotes important associational values that were recognized by Tocqueville 200 years ago. It can also help prevent fraudulent claims, since the existence of a religious community can provide powerful evidence for a claimant's good faith. On the other hand, I argue that the presumption should be rebuttable in particular cases. Categorically limiting legal protection to collective beliefs and practices would slight an important American tradition of honoring individual religious conscience and would entail difficult line drawing problems. So for me, the proper definition of religion would be a flexible one, but with community at its core. The more a plaintiff can tie his or her beliefs and practices to those of an established religious community, the more the plaintiff's claims should qualify as religious for RFRA and other legal purposes. By contrast, the further a plaintiff diverges from a religious community, the more idiosyncratic his or her spiritual path, the less plausible the plaintiff's claim to exercise a religion becomes. Now, to be sure, this approach doesn't settle questions in the manner of a bright line rule. It considers specific facts and depends a great deal on judgment. But I think it would offer the benefits of tying religion to common understandings and avoiding some of the problems associated with defining religion in entirely idiosyncratic terms, while remaining true to our cultural and legal traditions and minimizing the difficulties that a more categorical approach would entail. So I think I'll leave it there, and I'm happy to answer any questions later. Thank you.